entitled before. Ms. Dull, anything to argue? I mean, I don't, it's not an invalid sentence. It's not an illegal sentence. It's really correcting an error made by the court on probably a busy Monday morning.
I just asked the court to correct the error of 40 days instead of the actual 4 days credit. So I would ask the court to amend the correct the judgment to state 4 days credit instead of 40.
Mr. Harrison, besides obviously the defendant wanting to have a lesser sentence, anything to argue?
I'm a little bit, and I warned the court of this earlier, I'm a little bit confused because is the court using the nomenclature that this is in fact a valid sentence, or has it become invalid due to the typographical error?
You know,
Is there a catch-all court rule that simply allows us to correct errors?
Yeah, hold on.
This is what I'm trying to look up. I apologize to the court.
So Michigan Court Rule 6.429.
It's 6-something.
Hold on, let me take a quick look. 29. The court may correct an invalid sentence on its own initiative after giving the parties an opportunity to be heard, which is what we're doing now. But the court may not modify a valid sentence after it has been imposed except as provided by law. Any correction of an invalid sentence on the court's own initiative must require 6 months, or must occur within 6 months of the entry. Well, we're within 6 months, but that's not the question, because it's not necessarily, well, actually it is an invalid because the court awarded further sentencing credit than he was entitled, to which he was entitled underneath the law. So, because otherwise a court would consider giving additional credit by then reducing the punishment through the sentence. So I believe that what I'm doing is correcting a clerical error that was made by the court, as it's an invalid sentence, as he's not entitled to the additional credit. It's not liking it, which I completely understand. Also, we can look at Michigan Court Rule 6.435. This is correcting, that's correcting mistakes, clerical mistakes in judgments, orders, or other parts of the record, and errors arising from an oversight or omission may be corrected by the court at any time on its own initiative.
I think that's the one that I was focused on. I couldn't find it in my head, but that does make sense to me.
So the point here is he still retains all of his other rights to appeal if that's something he's doing or has initiated. I don't know if he has, but I think there's an argument underneath both court rules. So the court, therefore, on an accentuate under 6.435, the court corrects the clerical error, and the court references 6.425 as invalid, as he's not entitled to the additional credit. Therefore, the court reissues the sentence, however, corrects the credit dates. It should have been 4 instead of 40. Mr. Whiskey, that still means that you have the right to appeal your sentence of conviction. Doing so is by an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete a copy of the document regarding your appellate rights and return it to the court within 42 days from today's date. I think your 42 days begins again based upon this court correcting the sentence.
That was my next question, Your Honor. Thank you.
All right. Any questions, Mr. Whiskey?
No, Your Honor.
Thank you very much.